Good evening. Welcome to the Local School Advisory Team's Open Meetings Act training. Thank you all for taking the time to join us this evening. I am Sheree DeBerry. I am an attorney advisor with the Office of Open Government, and we have Director Niquelle Allen with us, and we have Chief Counsel Johnnie Barton with us. We are three of the four people that currently make up the Office of Open Government. We welcome questions that you may have. Please send them via chat. The questions will be addressed at the end of the presentation. The Office of Open Government is a separate office with the Board of Ethics and Government Accountability. The independent agency enforces the Open Meetings Act and regulations, DC Official Code, DC Official Code Sections 2-571 to 2-580. 3, DC Municipal Regulations 10400. The office contacts are, as I said, Director Allen, Chief Counsel Barton, myself, Sheree DeBerry, and we have an IT specialist, Mr. Kevon Bridges. The Office of Open Government educates the public as well as public bodies on the requirements of the Open Meetings Act and the District of Columbia Freedom of Information Act, DC FOIA. The Office of Open Government provides training as well as advice on the OMA and DC FOIA. The Office of Open Government advocates for government openness and transparency. Why do we have open meeting laws? The public policy of the district is that all persons are entitled to full and complete information regarding the affairs of government and the actions of those who represent them. What is a meeting as defined by the OMA? The definition of a meeting is very important. A meeting as defined by the OMA is a gathering of a quorum of the members of a public body. The public body members consider, conduct, or advise on public business. Public business may include gathering information, taking testimony, discussing, deliberating, recommending, as well as voting. Meeting gatherings may be held in person, by telephone, video conference, or by other electronic means of communication. The definition of a meeting is important, and the definition of what is not a meeting is also important. A chance or social gathering where no business is discussed is not a meeting. If your LSAT members are together, will run into each other, say you're in a store and you run into each other, a chance encounter, that is not considered a meeting. Or if all of the LSAT members are invited to, say, a holiday party where you all gather and there's no meeting discussed, no public business discussed, that is not considered a meeting. Press conferences are not considered meetings. Email exchanges, common form of communication, email exchanges between members of a public body are not considered a meeting. Subcommittee meetings are also not subject to the Open Meetings Act. Subcommittee meetings are usually small, less of a quorum, where no official action is taken. The subcommittees usually do not make decisions on behalf of a public body. And if there's no quorum, then the public body cannot conduct a meeting. A quorum, the definition of a quorum is usually half of the members plus one, unless the enabling legislation, mayor's orders, or regulations states otherwise. What is a public body? Local school advisory teams and other similar entities are that must adhere to the OMA are public bodies. Examples of public bodies, the government councils, including the Council of the District of Columbia, boards, commissions, board of directors, advisory boards that take official action by the vote of its members convened for such purpose, and boards of trustees of public charter schools. These are all examples of public bodies. What is not a public body? A district agency is not a public body. The mayor's cabinet is not a public body. The advisory neighborhood commissions is also not public body. ANC commissioners are not considered public bodies. District of Columbia courts and professional staff of public bodies outside the presence of a quorum. Open meetings. A public body's meeting must be open to the public unless there's justification for a closure. And we'll go into the justifications in a second. A meeting is open if the public is permitted to physically be present, if the news media is permitted to be physically present, and also if the meeting is televised. And those are all situations where the meeting is considered open. Notice of meetings, DC Official Code Section 2-576. Public bodies must give as much notice as possible, but notice must be given 48 hours or 2 business days before each meeting, whichever is greater. Notice must be physically posted in the school, the office, or a place readily accessible to the public. Notice must also be posted along with the proposed agenda on the LSAT's website, as well as the district government's website, which is called the Central Meeting Calendar. So LSATs have to make sure the information is posted on their websites, as well as the Central Meeting Calendar in both places. The access to the Central Meeting Calendar at www.open-dc.gov. You may contact the Office of Open Government's IT specialist, Mr. Kevon Bridges. You can contact him to be able to get your credentials to be able to add information to that calendar. Local school advisory teams must also obtain an email address that combines the name of the LSAT school as well as an acronym LSAT to conduct all official business. So the public body has to make sure there's one official email address that has the name of the school and LSAT connected, that the members of the local school advisory team will use for all official business. LSATs must also timely post upcoming meetings and also list an annual schedule of meetings to both the LSAT's website and the district government's central meeting calendar. Proper notice allows for sufficient time to be able to correct possible defective notice. Say, for instance, it's an incorrect date or incorrect time. If you give proper notice, then you'll be able to go in and make the corrections in time, and the public will still be able to attend the meetings. What should be included in the notice? Time, date, location, and the proposed agenda should all be included in the notice. And if there's going to be a closed session, the agenda has to specify this OMA citation to justify the reasons for the closure. So if you're planning to have a closed session, you must have the citation on the proposed agenda in order to be able to go into the executive session or closed session after the public business is discussed. The following statement also has to be at the end of all draft and final meeting agendas. This meeting is governed by the Open Meetings Act. Please address any questions or complaints arising under this meeting to the Office of Open Government at opengovoffice@dc.gov. And you can find this statement in the OMA regulations. Some of the closed meeting justifications are court order, statute, where it's a law or statute stating that this particular matter has to be discussed behind closed doors. If you're negotiating contracts, that's a justification. Any type of negotiations. The attorney-client privilege is a justification, but the attorney has to be given some type of legal advice during the deliberations. It can't be the attorney is just present at the particular meeting. If trade secrets are discussed, testing, grading, personnel issues, matters involving students' personal information, those are some justifications for closed meetings. Also, evaluations by eligible chartering authorities, training of staff, collective bargaining negotiations, administering, preparing, and grading tests, deliberations, public safety, as well as investigation. Those are some of the justifications for closed sessions. And again, I have to stress that you have to have the proper citation on your agenda in order to be able to go into the closed session. You can't just go into a closed session without the proper justification. The protocol for a closed executive session: the presiding officer opens the public meeting and then establishes a quorum. Because as I stated before, if there is no quorum, a meeting cannot take place. And at that time, the public business is addressed, conduct business for the open meeting. The presiding officer will move into the executive session. Another member would second the motion to enter into the executive session. The second motion has to reference the OMA citation, the justification for the closed session. Then a roll call is taken. If motion passes, you're able to enter into the closed executive session. Once you're in the closed executive session, you're only able to discuss the matters referenced in the draft agenda. So once again, it's very important that you list every issue or matter that you intend to discuss in the closed session, because if it's not listed, you're not able to discuss that particular issue. And all meetings have to be recorded, open or closed. They all have to be recorded by electronic means. Once the closed session has ended, the presiding officer will reopen the public meeting and when appropriate, report back what official action was taken in the closure and adjourn. Recording requirements. The Office of Open Government has opined that it's feasible to record all meetings by electronic means. And the recordings can be via audio recording, video recording, transcript, or detailed meeting minutes. If you're using transcripts, you have to confer with the vendor to make sure that there are no copyright restrictions with your intentions of posting the minutes for the public. And detailed meeting minutes. Detailed meeting minutes are more than just bullet points. Details, the minutes have to be so detailed as to to be so specific as to one could read the minutes and ascertain exactly what took place in that particular meeting. Publication requirements. Publication requirements can be found at DC Official Code 2-578. Draft detailed meeting minutes must be published no later than 3 business days after the meeting has taken place. And there must be a notation included at the top of that document that says final meeting minutes will be posted to the website on the next meeting date. Audio recording, video recording, and transcripts, which are considered a copy of the full record, must be available no later than 7 days after the meeting. DC Official Code Section 2-578 requires preservation of all meeting records for a minimum of 5 years. So it's very important that all records are maintained and records are not destroyed. Public bodies are meeting remotely during the public health emergencies, and to properly conduct a electronic meeting, members can meet via video, electronic conference, or other electronic means if they make reasonable arrangements to accommodate the public. And examples of public accommodations would be WebEx links, Zoom, Teams, conference calls set up for the public to see and hear the meeting. Meetings all must be recorded by electronic means. All votes are taken by roll call, and all provisions of the OMA are adhered to that are not waived or told. Public health emergency rules. Physical postings at schools, offices, or other physical locations are not required during the public health emergency. The recordings, the act has paused or told the time period for making a copy of the recording available during the public health emergency, but the Office of Open Government recommends that you make them available as soon as possible after the meeting. Public comment is allowed only if the public body's enabling legislation or bylaws mandate a period for public comments. However, a public body may allow public comment absent a statutory requirement to do so. Unless the requirement is already spelled out in enabling legislation or bylaws, a public body has the right to regulate the time allotted and duration of public comments if they choose to allow them. So that would be a decision made by the public body. Cancellation. How do we cancel meetings? A meeting cancellation is considered a change in schedule. In most instances, it requires as much notice to the public as possible, but not less than 48 hours or 2 business days, whichever is greater, before the meeting was to occur. Can emergency meetings be held? Yes, emergency meetings can be held. You are to give the public as much notice as possible, and notice must be given to the public at the same time as given to the members. Once the meeting begins, there has to be a statement explaining the subject of the meeting, as well as the nature of the emergency and also how the public was provided notice. The complaint process. One of the statutory charges of the Office of Open Government is to enforce violations of the Open Meetings Act. Violations such as improperly having a closed door meeting, recordings, or detailed meeting minutes not being posted in a timely fashion. Those are 2 examples of possible violations of the Open Meetings Act. An aggrieved party who may be anonymous may complain to the Office of Government for relief if a meeting may have been conducted in violation of the OMA. The complainant may refer to past meetings. A complainant may submit the complaint in writing, in person, online, via mail, or email. And Director Allen may seek to resolve the dispute through conciliation. She may decide to dismiss the complaint, issue an advisory opinion, or take any other steps permitted by the OMA and the OMA regulations. But once the complaint is received in the Office of Open Government, we acknowledge the complaint, notify the public body that a complaint has been made, and specifically detail what the issues are. And the public body is given 30 days to respond to that particular complaint, and then we move forward from there. Enforcement. The Office of Open Government may bring a lawsuit in the Superior Court of the District of Columbia for injunctive relief for any violations of the OMA before a meeting takes place or after a meeting has taken place. The court may order an appropriate remedy, such as requiring additional forms of notice, postponing a meeting, or declaring action taken at a meeting to be voided. And this enforcement is covered under DC Official Code Section 2-579. Our goal is to train and advise and to help answer questions. There's only been one lawsuit filed since the office has been enacted. So please do not hesitate to call, ask questions if you're unsure about anything. We're here to help, and we're here to make sure that your team is in compliance with the Open Meetings Act. Here's the contact information that we have. Our IT specialist, the individual who you can contact to if you need access to the Open Meetings calendar. The central meeting calendar is Kevon Bridges. Kevon.bridges@dc.gov. You can contact him and he'll be able to direct you in the right direction. And if anyone has questions, we'll take questions via chat now. I don't see the chat, if anything is there.
Hi, Sheree. This is Niquelle. I don't see anything in the chat either.
Okay.
I don't see anything.
Okay. All right. Let me see.
We've got one question from Ms. Winston. Will we be provided a copy of this slide deck?
Yes, you can be provided a copy of the slide deck, and also the presentation is being recorded and it will be on our YouTube channel. Is that correct, Niquelle? Director Allen?
Yes, we'll post it on our website as well as our YouTube channel after this meeting has concluded. And if you would like to send one of us your email, if you need it emailed to you directly, we can email it to you.
I think that's it.
I see one in the Q&A. Hold on a second. All right, thank you for this meeting presentation. Do you all have a suggestion as to what frequency we should host LSAT meetings?
I don't have a suggestion as to a frequency. Do you all have, what do you all currently, how frequent do you have meetings now, presently?
I would say in response to that should take a look at your rules, and your rules should dictate how often you should meet. So that means like your bylaws or any type of guidance that comes from DCPS. I believe you'll have a website that puts the regulations forth. A lot of our other public bodies in the District of Columbia meet once a month. I know that's probably not realistic for you because of the school calendar is different than the regular government calendar. So I would take a look at that and first ensure that there's no meeting requirement from what we would call your enabling rules. And, you can get those from DCPS as to the frequency of your meetings. So we can also kind of take a look into that for you further. Okay, so we have Tiffany Brown who has several questions. Can you promote her?
I've been unmuted. I'm
unmuted.
unmuted.
Oh, okay.
So I'm an LSAT chair at a school, and I have been for several years. And DCPS does have guidelines as to that we should meet every month. But my question comes around
Thank you for that.
saying that we should have an email that is specific to the school and LSAT membership, that things should be posted on a website and recording. So I don't remember what the guidelines say, but I've never seen that in the LSAT guidelines. As far as the website, posting things to the website, I know that I've never seen that in the guidelines. And recording of meetings, who pays for that? Because we've not been given, as LSATs, have not been given a WebEx account or a Zoom account. And then, listening to all the things about like audio, video, transcripts, it's kind of like, wow, this is being thrown on us. And like I said, I've been an LSAT chair for a very long time. The school that my kids attend has been in existence for about 8 years, like 10 years. And I've been the LSAT chair for 9 of those years. And none of this has ever been, this information given. So my question is, how does that happen and who pays for it?
Okay, well, this is new. We issued an advisory opinion on the topic. I think Attorney Barton, that was 2019, I believe.
Niquelle, it was specifically, it was January 14th, 2020, where you sent out the directive letting everyone know that about the LSAT in the email.
Okay.
January 14th.
So there was a two advisory opinions, and then I also issued a directive to implement those advisory opinions. So the question of who pays for it, I think that's a DCPS question. There are a lot of free resources as far as recording meetings. I see someone saying using Teams for LSAT meetings. Yes, so Microsoft Teams should be available to you. So we don't require transcripts. That's different. Transcripts do require a court recorder, a court reporter. That's not required. But what is required is you could use your cell phone to record the meeting. It could be an audio recording. It doesn't have to be an audio and video recording. So there are a lot of things available, such as Zoom, that are free that you could use. And I know I see that since parents don't have access to Teams account.
So I wanted to say that, so I'm a teacher also, and yet Teams is only if you're an employee or if you pay for that account. So that's not a viable option. We have to remember that LSATs are made up of teachers, staff members, and parents. So I just happen to be a parent that is a DCPS teacher. So these things being put in place, so I guess I'm looking at the statute, like how could this be put in place when the budgetary part was not thought of? And LSAT chairs, our emails are on the DCPS website. I've not gotten an email about this from DCPS or from Bega or from anyone else. So I'm like, there may have been an opinion over a year ago, but I know for me, I feel really blindsided by this. Like, what? We have to do all of this?
I'm not sure why you didn't get it, but we sent everything out through DCPS. And help me remember the gentleman's name, who was the communications officer as well as the general counsel's office, sent the information. Eli
Eli
Hoffman.
Hoffman.
Eli Hoffman, okay.
Yes, he sent the information out when it first came out, and we had a training back then as well. As far as resources go, we can certainly help you work with DCPS to get you accounts that you may need to hold virtual meetings. I mean, if you are meeting virtually, how are you meeting now?
So what I'm saying is that we are meeting virtually, and we use just like the PTO has theirs, and I'm using my own personal Zoom for LSAT. But the fact that this is statutory, but yet there's no money behind it. And so there's a requirement, but yet there's no funding to make sure that it happens. And so, you know,
Well,
you may not know this, but in DC public schools, we get a lot of mandates, but without funding. So I'm like,
yes.
on the parent side,
So
how does this happen?
Different than the Open Meetings Act was in existence before. I guess you're 8 years when you joined. You are new to the Open Meetings Act because at the time it wasn't interpreted to include LSATs. But given the nature of LSATs and the fact that you decide on government business, this is why the accountability piece was added to these meetings. It's a DCPS question as far as funding to implement this. You know, when you're talking about statutory funding, that's something that's completely different than what this is. So what we'll do for you and for others, if you would like to reach out, if you have problem with resources, we can facilitate a connection with DCPS or with the school principals to help you get on Zoom, to help you get on WebEx or any other type of meeting platform.
So Ms. Allen, that's not what I'm saying. I'm saying globally for all schools. My school, resources are not a problem for the school where my kids attend or the school where I teach, but globally, this mandate is being put in place, but it's not accessible to everyone. The fact that there are only 16 people on this call is, you know, one testament to it. So I'm saying that this is a requirement. How do we make sure everybody has
Ms.
it?
Brown, we have several of these meetings, so just because there's only 16 people at this one is not a reflection of the general ability of this office to educate everyone. We've been having trainings since the beginning. So globally speaking, that's a DCPS question.
Okay.
Okay, I have another question from Mr. Hendricks. Do we decide we are an advisory board for school principals? This may be a part of the question. Hold on. Mr. Hendricks, could you kind of clarify this question? I'm not sure what that means. Do we decide we're an advisory board for school principals? Okay, he'd like to speak, which is fine. And let me move on to that. Next one, schools don't allow you to send emails to the school community through their email list. Can you tell them they should allow LSAT chairs access for these purposes? We will communicate with the folks at DCPS about that. And
Niquelle, I unmuted Mr. Hendricks if he wants to ask the question.
Yeah, hi. This is Cedric Hendricks. I'm the chair of the LSAT at the School Without Walls at Francis Stevens. And what I was reacting to in that comment was the point that was just made that the decision was made that LSATs had to comply with the Open Meetings Act because we make decisions. And so my response was manifest in the name, local school advisory team is the charge to advise the principal, not decide the school's business. Now, when we look at enrollment and comment about enrollment, I don't characterize that as decision-making. When we look at the school budget and we advise the principal about the budget, which ultimately the principal finalizes and submits to the headquarters, we're not deciders there. So I'm just reacting to that statement and wondering then, if we're not a decision-making body, why then do we have to do all this new stuff? And I say
I'll
new
have to,
stuff because I too have been an LSAT chair for a few years, and this is the first time I've heard about this stuff in this level of detail from your office. I'm glad to finally hear it, grateful to say the least, but and want to do all we can to comply. So that's why I asked earlier to send us the slide deck. I have an LSAT meeting at 7:30 in the morning, and I want to be able to share this information with my colleagues. Thank you.
understood, and thank you for that. I will pitch that over to Mr. Barton, our Chief Counsel, to explain kind of the weeds of it. But it's the influence piece from my recollection, and we can send you a copy of the advisory opinion if you'd like to read it, and it gives the full details of the basis under which LSATs were put under the Open Meetings Act, and it has to do with there was a statutory basis as well as it's been a while, so forgive me. So I'll pass it over to Johnnie, because there was a legislative history and other things. It was very well written. So if we just say so, it explains in detail how we got to the conclusion. So I'll throw it over to Chief Counsel Barton.
Thank you, Director Allen. Hello, Mr. Hendricks. That's a very good question. It's not necessarily decision making, but the LSAT actually, and you stated it, provide advice. There are countless public bodies in the District of Columbia that do the same thing. They provide advice to agencies, agency heads, advice even to the mayor. So it's not dispositive that the public body make a decision per se, but the fact that they make advice that ultimately is used to make decisions that affect the government and how the government is run. And I hope that clarifies it for you. If not, I can give you my direct number, and I'm happy to talk to you at length about it.
I'm clear. I understand, and I appreciate that.
Well, thank you so much. You're very welcome.
Okay, I see another question from Ms. Wilner. Do you know if the email address has to be a k12.dc.gov account, or can it be a Gmail or other such server? Yes, it can be a Gmail account or any other such server. It doesn't have to be a k12.dc.gov account. Let's see. I may have missed a couple. I see. Did we get everyone's questions? My view is not allowing me to see all of them, so give me a moment, Sheree. But while I'm doing that, as director, again, I just want to take this opportunity to thank all of y'all for being here today. And, you know, we appreciate you working with us and with DCPS to make sure that we're able to implement these rules in a way that provides accountability. And we do understand the nature of the LSAT. Again, that's why we're making sure that we host multiple trainings to try to train as many people as possible. This information today in its entirety will be on our website. So if you'd like to direct other of your LSAT members to view this presentation, as well as these questions, that will be available shortly. I will try to get that done as soon as possible. Let's see.
I see one other question. can you define what official business means that you would need to use the school LSAT email account? You want me to answer it? Okay. Any business that you do that you have to disseminate to the public, you want to send it from the LSAT account rather than your own account, and it's for reasons to protect your personal email account from a possible FOIA request. So you want to separate if you're discussing business with a parent that deals with the LSAT, you want to use that LSAT email address rather than your own personal email address. So anything that you do in the meeting, anything about the meeting, if someone calls and someone requests a copy of the meeting minutes, you send that through the LSAT email address. If someone wants a copy of the notice, they say, well, I can't get it on my website right now. I can't get it on your website right now. Can you email me a copy of the agenda and the notice? You would use that LSAT account. So any business that is business done by the LSAT and not your personal business you should use that email account for.
Okay. The other one, can DCPS be made to create email accounts for all the LSAT? I believe we attempted to do that, Johnnie, but we don't.
We attempted to, and it was not technologically feasible with the Gmail account. It's sort of transferable to the next coming LSAT, and it's an easier way to do it because the LSATs are technically not government. They're not technically. It was some technical issues, but they say it's just not technically feasible to do it. And for the same reason, LSATs don't have to publish in the register. So that's another reason why the LSATs publish on the central meeting calendar as well as their own website. It's just not technically feasible for them to do so.
Are there any other questions? Okay, I don't see any more. So I'll turn it back. Oh, one more. Okay, go ahead with that, Johnnie. I can't.
Will the school's website suffice, or will we have to have our own website? The school's website will suffice, as well as the central meeting calendar. So, I think the LSATs in existence now have it through the school, and you can also use, of course, our central meeting calendar is already set up. You just need to get the credentials to post and to publish.
Hello, am I unmuted?
Yes, Ms. Brown?
Yes. Oh, great. Hi. I wanted to know that with the email that the LSAT creates, since within DCPS guideline, principals or supervisors are not they are not members of LSAT, but they are essential players within LSAT because the LSAT advises the principal. Will principals be a part of the email that's created, or is it just the members that are advising the principal a part of the email? It seems like a conflict of interest, but I just wanted to be clear.
Okay, can you clarify your question? Are you asking whether the principal will have access to the email?
Yeah. So once, So once there's an LSAT email, should the principal be accessed? Should the principal have the login and information like that? to that LSAT? Because the LSAT members may have access to the email, or who has access to the email? That may be the question. Who's the one?
Well, I think some of that will be left up to the LSATs themselves, minus the principal, or I think there's a teacher member as well on the LSATs. But that will be left up to you all who has that, who all has access to it. Again, the principal is not a member per se of the LSAT, so you can discuss it probably a little bit more in detail if you want some issues with DCPS General Counsel's office as to how they think it should go. But there's a clear distinction between the LSAT members and the principal. So I'm saying this from my perspective, but please check with DCPS General Counsel. I would deem only the LSAT members as having the log on information and the like for the email address.
Okay, I'll definitely follow up. Yes, thank you.
And I can follow up on your behalf.
That would be great.
if at the end of the presentation is my email address. My name is Johnnie Barton. Just shoot me an email and I'll be happy to get that information. Do an email to DCPS General Counsel and we'll get it clarified as soon as possible.
Thank you.
Are you very welcome?
This is Tiffany Brown. I have a question. When Sam Brown was talking, it made me think of something else. When you said, when you're stating email address, is it for each LSAT member, or that the LSAT should have an email address, one email address?
It was envisioned that the LSAT would have one email address that the members have access to, so that they can send and receive emails or read emails, and that they use that email address to disseminate information on public business.
Okay, so there's nothing that prohibits LSAT members from creating, like, because there are 4 parent representatives, so there being 4 LSAT email addresses. There are at least 4 parent representatives, because the guidelines say that you can add additional parents for whatever reason.
Director Allen, do you see an issue with that? I don't see one.
I don't. And again, the idea behind it is that you all are conducting government business per se. So that information is FOIable, as Attorney Barton mentioned. So for practical reasons, if there was a FOIA request for information related to your public body, to your LSAT, you don't want to have give access to your personal email for that purpose. So that's really just the reasoning behind it.
Okay. So I guess I'm kind of thinking back. So then if that is the case, then the district government should provide us with email addresses, even if it's just one for each school. So that it's not for, so that we don't have. So I have another position that's a DC government position, and I use that email for that business, and I don't use my personal email because of FOIA requests. And so I'm thinking, if this is something that can potentially be an issue, then DC Gov should give us an LSAT with the school initials at dc.gov. Is that something that we cannot get? Just one email address, or is that something we should go through DCPS for?
We certainly agree with you. And if you're able to advocate to DCPS to do that, we support that.
Okay.
Again, Director Allen's purpose in issuing that directive was to make sure we appreciate so much your service and to ensure that LSAT members were not inconvenienced by having someone request something from their personal email address. So based on our conversations with DCPS, this was the conclusion that was reached, but Director Allen, I'm with you 100%. If DCPS can do it, then that would be great. I see one other question. Will DCPS revise their LSAT guidelines to include this information? I believe they intend to. And we will suggest that they do if they haven't already done so that it's disseminated to everyone. But we believe that that's their plan. And again, I'm speaking from not from the General Counsel's Office of DCPS, but from I think a conversation I had with someone, if I recollect that correctly.
So I see the question was it Octo that said it was too difficult or DCPS? Who do we need to reach out to about providing us email accounts?
I don't recall exactly. I know the answer came through DCPS. I don't know whether it was Octo to DCPS or just DCPS. So again, we can revisit, that matter also. We can let DCPS know that it's an ongoing issue and that you all will be contacting them as well to try to get it resolved.
And our seasoned LSAT members, if you all would take the initiative and reach out to DCPS about the email issues, and that would be greatly appreciated. Any support that we can provide for that endeavor, we're here to provide that support. But it would come probably from DCPS's budget or their licenses that they have for email addresses and email accounts. So it probably is a DCPS issue, I assume. That would be my assumption from being in DC government for a long time.
Can you put your information in the chat? Because I'm going to do some things. I'm looking at the LSAT guidelines, and nothing on here tells us that LSAT said we need to have our own website. And I've looked up the whole email thing, and none of that says that. So I think that, because there are a lot of LSAT chairs who have been around for a while. Actually, I'm on my way out for being chair.
Niquelle, I'll type your email addresses and
I put my email in the Q&A. And I'm my email, well, it's my first name, my last name, Niquelle, NIQUELLE.Allen, ALLEN, @dc.gov. My phone number, which I'll also put in there, is 202-557-0087. That's my cell phone number. So I almost always answer it, but I will get back to you if I don't answer it. 0087. So I put both of those in the chat. Hopefully you can see that. I'm sorry, I put mine in the Q&A, and Sheree put everyone's email in the chat. So yes, we are available to you for questions and for assistance and whatever you need. And again, we appreciate you being here tonight, and we would like to be of assistance to make this as painless as possible, I guess. And a lot of things you're probably doing already. It's just adding tweaks to your operations to make sure that the public and others are aware of the important work that you do.
And we truly appreciate everyone's service.
And I'm a proud product of the DC public school system. So I thank you, even though I'm out of the system now, but I thank you for your work. And I remember how diligent PTAs were in my day. So I know it's a lot of work, but believe me, it's appreciated. And we do appreciate so much your work.
What school, Mr. Barton?
I went to, most of the schools I went to are actually no longer in existence. I went to Woodridge Elementary School, which is now a charter school. I went to Taft Elementary, which is now a charter school. I went to McKinley Tech, which is still there, but I didn't finish there. I went to Randall Career Development Center, which to me was one of the first kind of like magnet schools in the area, which I graduated from. It is now closed. So my footprint, as far as the schools I went to, they no longer exist in, you know, in reality. The buildings are still there, but the school names have changed, and one's closed.
Is Randall in Southwest? That Randall?
Yep, First and 9 Southwest.
Okay.
All right, if you don't have any, I can't see the questions, Niquelle, so if they're not in
I don't see any new questions. I think we have responded to all of the questions in the Q&A and in the chat.
Okay. And once again, we truly appreciate everyone taking the time out tonight. I think it's been we've had a very informative session. We appreciate all your questions. And as I said before, email us, call, whatever it is you need, whatever questions, we're here to help and advise and make sure that you all are in compliance with the Open Meetings Act. And have a good night, everyone.